Welcome back to Legal English. In today's lesson, we're heading into the legal traditions of Latin America, where civil law systems dominate. If you've ever compared legal systems around the world, you'll know that civil law functions quite differently from common law, which is in the United States and England. We'll focus on key legal terms like civil code and jurisprudence, explore the passive voice in legal explanations, and practice using time expressions to talk about legal developments. By the end of this lesson, you'll be able to explain the basics of civil law traditions with confidence in both writing and conversation. Here's what we'll cover today. We'll start with essential legal vocabulary that describes civil law system, like civil code, doctrine, jurisprudence. Next, we'll explore how the passive voice is used to explain laws and court decisions, a useful tool in legal writing. Next, we'll also review time expressions that help describe legal change over time, which is very useful when discussing reforms or historical developments. And finally, we'll compare civil law to common law systems, focusing on how they differ in their use of precedent and legal sources. Let's get started. When we talk about a civil law system, certain terms immediately come to mind: civil code, written law, doctrine, and perhaps even Napoleonic law. In much of Latin America, these systems form the backbone of legal practice. Unlike common law, where precedent plays a central role, civil law relies on comprehensive legal codes. The role of the judge is different too. They apply the law rather than interpret it through past rulings. You'll also hear about legal scholars and doctrine, not just in academic settings, but as real influences on judicial reasoning. Understanding these concepts helps you engage with legal professionals across jurisdictions and speak their legal language with accuracy and confidence. The term civil code is at the heart of civil law systems. It's a detailed, written set of laws that covers everything from contracts and property to family obligations. In most Latin American countries, the civil code is the primary legal reference for private law. So instead of relying on past court decisions, lawyers turn directly to the code, article by article. It brings structure and consistency, giving both lawyers and citizens a clear legal framework. Doctrine. In civil law systems, doctrine refers to the legal ideas and interpretations developed by scholars. These aren't just academic theories. They're often used by judges and lawyers to clarify how the law should be applied. When the code is vague or silent on an issue, doctrine helps fill in the gaps. So, in a legal opinion, you might see a judge referencing not just the law itself, but also what leading scholars have said about it. Jurisprudence, in a civil law context, refers to previous court decisions. But here's the key: it doesn't carry the same authority as it does in common law systems. In Latin America, jurisprudence is persuasive. Judges may look at it for guidance, especially if the same issue has come up before, but they're not required to follow it. This is a big shift for lawyers trained in common law, where precedent is often binding. Legal scholar. A legal scholar isn't just someone in a university. In civil law traditions, their work can influence how judges interpret the law. Legal scholars write books, commentaries, and academic articles that help explain and develop legal principles. When judges are unsure about how to apply a code provision, they often turn to these writings for clarity. So scholars aren't lawmakers, but they do shape law indirectly through doctrine and interpretation. Codification. Codification is the process that gives us civil codes in the first place. It means taking scattered laws, customs, and court rulings and organizing them into one unified written legal code. The most famous example is the Napoleonic Code, a model for many Latin American countries. Codification brings order and accessibility to the law. It's one of the defining features of civil law, where clarity and structure are key. Statute. A statute is a law created by the legislature, Congress, Parliament, or the National Assembly, and written into official legal code. It's not just a rule, it's the formal expression of public policy. In civil law systems, statutes make up the bulk of legal authority. For example, the labor code in Costa Rica contains statutes that cover everything from minimum wage to termination procedures. When lawyers talk about the law, they often mean a specific statute, article by article, word by word. And in civil law context, the statute is where interpretation begins. Interpretation. Law isn't just about what's written, it's about how it's understood. That's where interpretation comes in. Judges, legal scholars, and even lawyers all engage in interpreting legal texts, asking, what does this statute really mean? In civil law systems, interpretation often starts with the literal wording. But when that's not enough, context, doctrine, and legal principles help guide meaning. For instance, two judges might read the same article in the civil code, but apply it differently, based on how they interpret its intent. Interpretation bridges the gap between written law and real-life cases. Precedent. In common law systems like the United States or the United Kingdom, precedent is king. A judge looks at what previous courts decided and follows that reasoning to stay consistent. But in civil law systems, like those in Latin America, precedent works differently. Judges may consider past decisions, especially from higher courts, but they're not bound by them. It's more of a guide than a rule. Still, in practice, certain court rulings, especially from a Supreme Court or a constitutional court, can shape how the law is applied across the country. So even though civil law doesn't rely on precedent in the same way, it's still part of the legal conversation. Constitutional Court. The Constitutional Court plays a unique and powerful role in civil law countries. It doesn't deal with everyday disputes like contracts or property. Its job is to protect the Constitution itself. This court reviews whether laws passed by the legislature are valid under the Constitution. For example, if a new labor reform is challenged, the Constitutional Court decides if it respects the rights guaranteed in the National Charter and the National Constitution. In countries like Colombia, Costa Rica, Germany, these courts have the final say on fundamental rights. Their rulings can change how all other courts apply the law. Judicial decision. A judicial decision is more than just the outcome of a trial. It's the court's official explanation of how the law applies to the facts. In civil law systems, judicial decisions don't usually create binding precedent, but they do matter. A well-reasoned decision helps clarify how the law is being interpreted, especially when multiple courts reach similar conclusions. For lawyers, judicial decisions offer insights into trends in legal reasoning and can influence future rulings through what's known as persuasive authority. So, while they don't carry the weight of precedent, they're still a powerful part of legal analysis. Here's a question for you. What's the legal term for the process of organizing laws into one written system? Let me tell you a story to explain. Imagine a country where the laws are a confusing mix of royal decrees, local customs, and religious rules. Judges and lawyers struggled to find clear guidance. Then a reformer steps in and says, let's organize all of this into one unified written system. The result is a clear legal code, easy to access and apply. So the answer, codification, which is the process of collecting and organizing laws into a single legal code. Here's a question to think about. What do we call the academic commentary that helps clarify legal rules? Imagine you're preparing for a case and find a vague article in the Civil Code. You turn to a respected professor's writings who has analyzed this area of law deeply for many years. His explanation clarifies the meaning and practical application of the rule. The answer is Doctrine, the academic interpretation of legal rules by scholars and commentators. Here's a useful question. What is the official set of laws governing private legal matters in civil law countries? Say you're helping a client with a contract dispute in Costa Rica. You start by consulting the Civil Code, which contains detailed rules on contracts, property, and family law. This book forms the backbone of private law in many countries. So the answer is, like you heard it, Civil Code. It's a comprehensive, written set of laws governing private legal matters. Here's a question to remember. What name do we give past court decisions that guide future rulings, even if they aren't binding? So imagine a judge in Argentina faced with a tricky commercial dispute. The law isn't clear, so she looks at past decisions from higher courts to find guidance. These past rulings are called jurisprudence. They influence how judges reason and decide cases, even in civil law systems. So the answer is jurisprudence. Let's switch it up. Now let's talk about some grammar. Let's talk about passive voice, a grammar structure that's everywhere in legal English. Why is it everywhere? Because in law, we often care more about what was done than who did it. For example, when a statute is passed, the important thing is the law, the statute itself, not always the person who passed it. That's where passive voice shines. The structure is simple. The subject, followed by a form of to be, then the past participle of the verb. For instance, the statute was passed last year. Or, a new civil code has been adopted. And the clause is interpreted by the court. Using the passive voice helps keep your language formal and objective. It's very common in judgments and contracts, where the focus is on actions and results. Also, sometimes the actor isn't important, or we don't know who did it. So the passive voice is perfect. So whenever you want to emphasize the legal action itself, passive voice is your go-to. Let's review the main passive voice forms you'll see in legal English, especially the present perfect and simple past. First, the present perfect passive. It uses has or have plus been plus the past participle. For example, a new law has been passed. This tense is great when the action happened sometime in the past, but still has an effect or relevance today, right now. Think of it like saying, this change is important today. Then we have the simple past passive. Was or were plus the past participle. For instance, the code was amended in 2010. This form points to something that happened at a specific moment in the past, a completed action. Both are common in legal documents, reports, and discussions. Knowing when to use each one helps you sound clear and professional. Let's start with since. Imagine a law was introduced in 2015. When we say the law has been in force since 2015, we're telling a story that begins at that year, 2015, and continues all the way to today. This use of since is powerful because it connects the past to the present, showing that what started years ago still matters now. It's like a timeline that starts at a point and runs without stopping. Next is for. Think about how long something has been happening. When we say legal scholars have debated this issue for years, we're telling a story about ongoing discussion that started some time ago and hasn't ended yet. It's not about exactly when the debate started, but how long it has lasted. Using for lets us emphasize the length of time over which this action continues. It's a way to show persistence or ongoing effort in legal discussions. Then there's over the past. This phrase paints a picture of a broad, ongoing period, like a story unfolding over time. When we say codification has advanced over the past decade, it suggests steady progress during those 10 years, not just a one-time event. It's a way to talk about development and change that's gradual and continuous, helping us understand how legal systems evolve over time. In recent years, this is a phrase that's a bit more flexible. It doesn't point to exact dates, but tells us something has changed or happened somewhat recently. For example, the court has ruled differently in recent years. Suggest there may have been notable shifts in decisions lately in the past 2, 3, 5 years, even if we don't know exactly when or how often. It's very useful when you want to highlight recent trends or shifts without getting bogged down in specifics or details. Finally, so far sets the scene up to this very moment. When we say no new amendments have been passed so far, it means nothing has changed yet. But it leaves room for things to change in the future. It's a way of telling a story that's still unfolding, where the present is the latest chapter. This phrase is common in legal discussions when tracking progress or updates. Now, my favorite section, the idiom section, laying down the law. Imagine a new civil code that comes with very strict rules on how personal data must be handled. When people say it lays down the law, they mean it sets clear, firm rules that everyone has to follow, no exceptions. This idiom paints a picture of someone or something like a law, firmly stating what's allowed and what isn't. So when a law says lay down the law, it's taking charge and making sure everyone knows the boundaries. Letter of the law means following the exact words in written legal texts. Nothing more, nothing less. In many civil law systems, judges focus strictly on the written codes, interpreting cases based on what the law literally says. Think of it as reading every word carefully and not going beyond the text. This idiom reminds us that sometimes the law is about the precise language, not just the spirit or intention behind it. Above the law. When someone is above the law, they behave as if the rules don't apply to them. In a healthy legal system, no one, not even powerful officials, should be above the law. This idiom highlights the principle that laws are meant to govern everyone equally. If someone acts above the law, it threatens fairness and justice because it puts them outside legal accountability. Test the waters. Test the waters is like cautiously dipping your toe into a pool to see how cold the water is before jumping in. Governments often test the waters by introducing small reforms or pilot projects to see if they actually work before making big legal changes. This idiom captures the idea of experimenting carefully, minimizing risk, and gathering feedback before a full commitment. Now, one of the most common ones in law, gray area. When we say something is a gray area, we mean it's unclear or not well defined by existing laws. For example, digital inheritance rights. Who owns your social media accounts or digital assets after you die? It's still a gray area in many countries. This idiom paints a picture of something that isn't black or white, where rules are fuzzy, not clear, or open to interpretation. In law, gray areas often need new legislation or court decisions to bring clarity. Let's finish with the big picture of civil law traditions in Latin America. It's the legal system that shapes so much of the region's practice. First, civil law centers on detailed written codes. The civil code is the foundation. Unlike common law systems where past court decisions carry heavy weight, civil law looks more to the written rules themselves. Doctrine. That's the work of legal scholars. It plays a key role. These experts interpret and explain the law, influencing how courts and lawyers understand the codes. Speaking of courts, constitutional courts have a special job, making sure law fits within the Constitution. Their rulings are critical to the legal landscape. You'll notice that legal language often uses the passive voice here, focusing on the action, not who does it. And time expressions like since, for, and over the past decades help describe ongoing legal developments. So, understanding these core features will help you navigate civil law systems confidently. Whether you're drafting contracts, advising clients, or interpreting legal texts across Latin America. So, to wrap up today's lesson, let's review what you've practiced and learned. First, the key vocabulary. Words like civil code, doctrine, jurisprudence, legal scholar, and precedent. These form the backbone of talking about civil law systems. On the grammar side, you've worked with passive voice in both present and past forms, plus time expressions with the present perfect tense. These tools help you explain legal developments clearly and professionally. Most importantly, you've gained a deeper understanding of how civil law differs from common law, especially how civil law relies on detailed written codes and places less emphasis on precedent. With this knowledge and language practice, you're ready to speak confidently about legal systems and describe complex legal changes in English, a skill that's invaluable in cross-border legal work. Thank you, guys.